Hi everyone, and welcome back to my channel. Today's legal topic is discovery. So if you're going through a lawsuit and someone has sent you discovery, I'm going to talk about the different types of discovery and give you a few cost-saving tips.
You may have heard people discussing discovery when a lawsuit is filed. So let's talk about what discovery is and the different types of discovery that you go through in a divorce or in any type of lawsuit. Let's take a look at the definition of discovery. Discovery happens pre-trial. That means that you need to obtain evidence from the other side and they get to obtain evidence from you before you have a trial. You can't have a trial unless you have some evidence. So each party is required to disclose facts, titles, knowledge, documents, all different sorts of things that you have access to that the other side does not. On the flip side of that, they get to ask you for the same sorts of things. Before you go to mediation or before someone goes to trial, each spouse will be required to disclose facts, titles, knowledge, and documents in order to have the most information available so that you can figure out what is a good deal for you or what you're willing to settle for in mediation. The other thing you need to know about discovery is that you are required to disclose things that are exclusively in your knowledge or exclusively in your possession. If someone has moved out of the house and they don't have access to the tax documents, the other spouse has to give them those. So that's a really great example of something that could be in one spouse's possession and not the other spouse's. Where do you go to find all of these Tennessee discovery rules? You go to Rule 26.01 and let me show you how to find any rule that you'd like to look at on your own. All of the rules in Tennessee are available online for free. Start by opening a new browser window on your laptop, tablet, or phone and log on to www.tncourts.gov. Next, hover over the word courts and you will see several choices on a drop-down menu. Go down to Court Rules. Once you click on Court Rules, you will see there are several different areas on the website. Rules of Court, Proposed Rules, Local Rules of Practice, and Rules of Evidence and Procedure. We want to choose Rules of Civil Procedure. Once that opens up, we scroll down because we know that in our case, we are looking for Rule 26. So scroll down through all the rules and you will see Rule 26. Once you do that, Rule 26.01 is discovery methods. Click on that and you can read the rules of discovery. Now that you know how to find all sorts of rules, including Rule 26.01 discovery methods, let's go back to the slideshow and start talking about all the different types of discovery methods. The first discovery method, and probably the most common, is depositions. Depositions can be oral or written. Let's start off with talking about oral depositions. When you receive a notice of deposition from the other side, that's a special court document that one of the attorneys normally prepares. You will be court ordered to show up at opposing counsel's office and give oral testimony. You might also go to a mutually agreed upon other location. A deposition that is oral is taken outside of court, but with the instruction or permission of the court. It is also what we like to call on the record, and that means a court reporter will be present There can also be a video of the oral deposition, and that's called a video deposition. Some other things you need to know about oral depositions are that you will be sworn in under oath. So normally the court reporter will just have you raise your right hand and you will be sworn in before the deposition starts. Oral depositions are not just limited to the two parties that are named in the lawsuit. Some other examples of people who may be called for oral depositions are your accountant, your business partner, someone that you or the other side have cheated with. There's a special name for those in a divorce case, and that person is designated as a, quote, paramour. So if you hear that term, that just means it's someone that you or the other person have been dating outside the marriage. And finally, it could include anyone else who has knowledge about your case that you want to have an oral deposition of. Finally, there are several people who are exempt from depositions, so consult with the attorney in the case to find out who those would be. The next method of discovery is called interrogatories. When we see the word interrogatories, we can think about the word interrogate. Basically, that means that each side can submit written questions to each other. They have to be in writing. They are going to be under oath, and there is a limited time to respond. Normally, that is 30 days under the Tennessee Rules of Civil Procedure, but sometimes the attorneys agree to extend that time if there are some particularly difficult questions, because as I said earlier, you have to write out the responses to the questions. Clients have to be careful when they are answering interrogatories because there is a new amendment to Rule 34 under the Tennessee Rules of Civil Procedure that requires any objection to an interrogatory to be made very specifically. In other words, you have to answer unless you have a very specific reason that you can't answer or a specific law or rule that you are citing that would allow you not to answer. Production of documents or things. Let's talk about it. Each side is allowed to ask the other side to produce documents or to produce things, just like it sounds. Production of documents and things normally goes hand in hand with interrogatories. Let me give you an example. If one side asks a client what their salary is, that's an interrogatory and is answered with a number. Then they could request, under request for production of documents and things, your last pay stub or your tax returns for the previous year. That is a way of supporting your interrogatory answer with a document. Finally, interrogatories and requests for production of documents normally have that 30-day time limit for providing the documents or the thing requested. Next up is permission to enter land or property. That's just like it sounds. It's when one side makes a request to the other side to enter land or property in order to gather evidence. We have two areas left to briefly discuss. The first one is examinations, and those can be physical examinations or mental examinations. Let's start with physical examinations. That is governed by Rule 35 of the Tennessee Rules of Civil Procedure. This rule allows for the physical examination of either party or someone that one of the parties has custody over. The examination has to be done by someone who is suitably licensed or a certified examiner, and the court can order that if one party motions for it. Of course, there has to be a good reason for the request, or the court will not grant that motion. Just like physical examinations, mental examinations have to be done upon motion by one of the parties. There has to be a good reason, and there needs to be a certified examiner. Thanks for hanging in there for the very last type of discovery, and that is requests for admissions. I know I keep giving you these rules and I've shown you how to look them up. There are certain clients that love to do their own research, so I've tried to include those whenever possible if you would like to go and look those up yourself. Requests for admissions are found in Rule 36.01, and there are very specific time limits that are set out in the rule. You definitely need to consult an attorney if you are served with request for admissions, because that can be something that can be very damaging to your case. Each request for admissions normally says something like, admit or deny that, and then there's a statement. It could also say, admit or deny that, and then it will have a document. If there is a document that there is a request for admissions for, the document has to be attached to the request for admissions. You don't have to go out and try to find that document, or the client doesn't have to go out and try to find that document for themselves. It has to be attached. And finally, you'll see here on the slide that I say you have to be very, very careful, because if you do not deny the request for admissions, it is deemed admitted by the court. Normally, you only have 30 days to admit or deny that. So make sure that that is answered in a timely manner.
Thank you for watching our tips on discovery today. If you liked this video, give it a thumbs up, and don't forget to click on that notification bell and subscribe so that you can be notified every time we make another video like this.